Hello everyone and welcome to the Aussie Time Sheets and Employsure webinar. We are pleased to welcome our presenters for today, Laura Willis, Ainsley Coomber and Michelle Thompson. This webinar is live and interactive and you are encouraged to post questions to the presenters throughout the presentation. If you are experiencing any technical issues during the webinar, please dial our support team on 1-800-733-416 and this number will also be listed in the chat box. I'd now like to pass you over to Michelle to begin.
Thank you. I'd like to welcome everyone today. I'm Michelle Thompson from Employsure. Ainsley, Laura and myself are excited to be holding this together today, as Aussie Time Sheets and Employsure have many things in common. Your business is our business, meaning we look after small to medium businesses, helping to keep your business fair, safe and profitable when it comes to employing staff. Aussie Time Sheets and Employsure support your business with tools to streamline businesses' process and productivity. Currently, we run events and webinars around the country to help businesses understand areas of the confusing legislations within Fair Work and workplace health and safety. Today is a general information session. Following this, we can arrange a private consultation with either Employsure or Aussie Time Sheets specific to your business. We will call you to arrange, but please feel free to register your interest through the webinar. I would now like to hand over to Laura from Employsure to run through today's Employsure session. Thank you. Have a great day.
Thanks, Michelle, and welcome everybody to today's webinar session. My name's Laura and I'm an Employment Relations Advisor here at Employsure. My role is to advise on a broad range of employment relations topics to our clients on a daily basis. So today's session will cover recent changes to the Fair Work Act regarding employers' obligations in record keeping and pay slips, and we'll also cover the importance of contracts and policies and how proper documentation can assist in ensuring that each business is legally compliant to avoid the risks of workplace claims. Everyone, please feel free to ask questions using the question box on the left. Please pop those questions in the question box throughout the session and we'll address those questions at the end. Okay, so where would you go to know your employees' entitlements? The Fair Work Act is the umbrella which provides a minimum safety net of entitlements for all employees, such as leave entitlements and protections from unfair dismissal. With over 120 modern awards that sit underneath the Act and regulate those minimum conditions of employment in certain industries, this includes minimum rates of pay, ordinary hours and penalty rates. These are all matters which can have a significant impact on your business. In addition, there is a whole raft of state-based legislation around workplace health and safety and also long service leave to comply with. Generally, business owners become familiar with the employment relations system because something has gone wrong, or they have been exposed to an authority like the Fair Work Ombudsman for an underpayment claim, or the Fair Work Commission because an employee has made an unfair dismissal application. If you do get it wrong, you could end up underpaying, paying too much, or facing big penalties. On the 15th of September 2017, the Fair Work Amendment Protecting Vulnerable Workers Act 2017 took effect, making some significant changes. In particular, those amendments included increased penalties for serious contraventions of workplace laws, clarifying that employers are unable to ask for a cashback from employees or prospective employees, increased penalties for breaches of record keeping and pay slip obligations, providing that employers who do not meet their record keeping and pay slip obligations and are unable to give a reasonable excuse for not doing so will be required to disprove any underpayments claims made against them. This is what's called the reverse onus of proof. These changes strengthen the Fair Work Ombudsman's powers to collect evidence in investigations and also provide an introduction to new penalties for giving the Fair Work Ombudsman false or misleading information or hindering or obstructing the Fair Work Ombudsman's investigation. Further, on 27 October 2017, the changes also saw implications for certain franchisors and holding companies who can now, in some circumstances, be held responsible if their franchisees or subsidiaries do not follow workplace laws about minimum entitlements, the National Employment Standards, awards, sham contracting, record keeping and payslip obligations. In relation to the increased penalties for contraventions of workplace laws, this occurs when a person or business knows that they are contravening an obligation under a workplace law, or where the contravention was part of a systematic pattern of conduct affecting one or more people. This includes a breach of the National Employment Standards, a breach of the Fair Work Act or an award or an enterprise agreement, or a breach of record keeping and payslip requirements. If an employee does make a claim for a breach and the employer has failed to keep those correct records, make records available or provide a payslip, the employer will be required to prove that they paid the employee correctly, including all of the correct entitlements. This is quite a onerous obligation on the employer to ensure that they have their record keeping and payslip requirements in check, particularly given that an employee can make an underpayment claim and the employer will be required to prove that they paid correctly. Penalties in some circumstances may amount to $12,600 per contravention for an individual, such as a sole trader, or $63,000 per contravention for companies. If the contravention is deemed to be serious, the court may order higher penalties of up to $126,000 per contravention for an individual and $630,000 per contravention for companies. So they're quite serious penalties at stake here. Other potential outcomes may include a court order to enforce payment of any amount plus interest, payment of compensation to the individual employee, a requirement to take an action such as audit or training, or restraint from the company doing something. In regards to record keeping, with many different and complex requirements set out in the Fair Work Act and each of the 120 awards, and a vast difference in each of those awards with regards to provisions for overtime, allowances, penalty rates, it's really critical for businesses to ensure that all record keeping is quite accurate. This includes making note of any start and finish times, meal breaks, rest breaks, any distances travelled, for example. The Act requires employers to keep information such as basic employment details, the commencement date and date of termination of each employee, all pay records, hours worked, leave entitlements, superannuation contributions, any individual flexibility arrangements, and any guarantees of annual earnings. Employers are required to make copies of employee records available for inspection and copying by the employee and former employees if requested, and in certain circumstances, union officials may have the right to inspect and copy those employee records as well. If a request to inspect or copy records is received, an employer must provide on-site access within 3 days, or alternatively post a copy of the requested records within 14 days. Under the Fair Work Act, employers have an obligation to issue a payslip to all employees within 1 working day of paying the employee. A payslip can be issued in an electronic form or a hard copy, so for example by way of email is sufficient. A payslip must include certain information such as the employer's name and ABN, the employee's name, the period to which the payslip relates, the date on which the payment is made, the employee's hourly rate and number of hours worked, the gross and net amounts of the payment, also including any bonuses, loadings, allowances, penalty rates, incentive-based payments, etc. Details of all those must be included on the payslip. Details of any deductions from the employee's pay. These must be lawful deductions being agreed in writing by the employee and principally for the employee's benefit. Details of any superannuation contributions as well. While the Act doesn't require leave entitlements to be provided and specified on a payslip, such as annual leave, personal leave, or long service leave balances, it is considered best practice to note these entitlements on the payslip. In any event, the employers are required to provide these details on request by the employee. How many of you have written contracts in place? If you don't have written contracts, what would you rely upon to ensure that your employees know the terms and conditions of their employment? If you don't have written terms in place, then you are left only with the Act and the award to determine those terms and conditions of employment, which are generally employee-friendly and not always clear to understand. As a safeguard for businesses, I strongly recommend that each employee be on a written employment contract, clearly setting out the terms and conditions of their employment. In addition, all policies and procedures of the businesses should be set out in the employee handbook to be distributed to all employees. Critical policies, which I see referred to on a daily basis, include disciplinary processes, notification and evidentiary requirements for absence, including personal and carers leave, drug and alcohol policies, and motor vehicle policies. Contracts provide certainty around your obligations and those of the employee by setting clear written expectations which can be enforced consistently across the board. If you don't have a written contract in place, an implied contract will still exist between you and your employee. However, it will be based on the conduct between you and the employee and the previous custom and practice that has formed over time. This often leaves the parties uncertain of the relationship and the terms ambiguous. As an example, you may pay your employees above the minimum wage, as set out in the modern award, and not pay annual leave loading. However, you would not be able to offset any payments above the minimum award rates of pay without specifying that term in this contract of employment and expressly stating that that's the case. Having all of the correct documentation in place ensures compliance with the statutory obligations. For example, upon commencement of a new employee, the correct suite of documentation should be provided, including a contract of employment, the employee handbook, and the Fair Work Information Statement, which is a requirement under the Fair Work Act. These also help protect your business. Modern awards generally protect the interests of employees and not employers. So that contract is important to protect your business interests, for example, through the provision of post-termination restraints and non-solicitation clauses, confidentiality and intellectual property clauses, and restrictions and determinations around the use of company vehicles and mobile phones. From an employee management perspective, it's important to clearly communicate your expectations to maximize the chances of employees meeting those expectations. Most employees want to or will do the right thing, but don't necessarily know what the right thing is. If you can communicate this to them early in the employment relationship, it will set them on the right path and avoid bad habits forming, which in turn will make it much easier for you to manage your employees. For example, notification of sick leave or absence. To ensure operational efficiency, employees should provide notification by telephone to their manager prior to their scheduled start time. If this expectation is not set, employees may get into the bad habit of sending a text, which can be easily missed and affect operational efficiency. For those who do not wish to toe the line, you have set out your clear expectations, which you can point to in the employee handbook if they don't comply. This gives you the ability to take action for misconduct. Contract and the employee handbook provide you with a range of options to address an employee who is breaching either their contractual terms or particular policies and procedures. Having the correct documentation in place puts you in the best position to enforce policies and procedures, set standards of behaviour, and reduce issues in the workplace. This in turn increases morale, productivity, and efficiency as you and employees can focus on getting on with the business rather than focusing on the drama, which can often exist in dysfunctional workplaces. We often get asked to insert all sorts of weird and wonderful terms into a contract of employment. However, the contract itself should be kept clear, setting out only the terms and conditions of the employment relationship which are to be legally enforceable. The terms of the contract cannot be amended or varied without the agreement of both the employer and the employee. There is no discretion for the employer to unilaterally vary the terms and conditions of the contract. Overall, the contract is in place to protect your business and provide certainty to the parties involved. The contract confirms the terms and conditions of employment that you can rely upon if a dispute should arise. On the other hand, the employee handbook sets out the policies and procedures which supplement the contract. The main point with policies is that they can create flexibility for the employer and the company, and the terms are discretionary. If you do need to amend at any point, we are able to do so with more flexibility. Policies are dynamic for this very purpose. This enables effective functioning of the business and ensures that the policies and procedures move and evolve with the business as it grows. Policies are discretionary, and the employee is not required to agree to the employee handbook, but needs to know that a policy exists and to follow those policies. What do you think the policies should not be incorporated into your contract? The policies are dynamic and are likely to change over the life cycle of the business. So a benefit for the employer is to have the ability to change those policies as situations change. Otherwise, if written into the contract of employment, the company would need to seek agreement, and a written agreement at that, from the employee to make any changes. Further, if the policies are incorporated into the contract, then the policies form part of those contractual legal terms, so may expose the business to a claim or penalty if the policies are not strictly adhered to. This has definitely caused some problems for businesses in the past, particularly where bullying policies have been incorporated into the contract of employment. Let's look at some key policies and how they can help you manage your staff and mitigate risks. Think about it. How would you manage if 2 employees ask for annual leave at the same time? Does your policies and procedures set out a leave policy which will give you the process to address such a question? The leave policy should provide clear and clarity in regards to the process of applying for leave, how your employees should notify you of leave requests, how they should notify and require the production of evidence, such as a medical certificate in the purposes of personal leave. There are safeguards that should be included in the policy, such as right to search, IT and computer policies, including monitoring and surveillance of computer records and emails. This policy would set out how employees must behave when using company property, websites they can or cannot access, using company's email system, and what is permitted and not permitted. How would you manage your employees if they posted offensive posts on social media? The Code of Conduct should also include specific provisions regarding social media to clarify the employee's responsibilities when using online posts to social media, outline how the employee can reference the company in social media, and set clear expectations and consequences if this process is breached. The grievance, disciplinary and performance management policies should also be clearly documented in the employee handbook. This sets out the procedure of how the employee can raise a grievance against an employee or a colleague or a manager in some circumstances, and what is the correct process in order to deal with a grievance complaint. The disciplinary process is of particular importance and a policy which I refer to on a daily basis for my clients. It sets out examples of what is considered to be inappropriate behaviour or misconduct, the steps which should be taken in order to deal with such conduct, and the potential consequences for employees, such as a warning letter or potentially termination. Similarly, performance management procedures outline the correct steps to be taken if an employee is not performing to the required standard. So how can the policies I have mentioned assist your business? The major area of concern here is unfair dismissal. In order to have access to unfair dismissal rights, an employee must have completed a minimum period of service. This is 6 months service for employers with 15 or more employees, or 12 months service for employers who are considered to be small businesses with 14 or less employees. A further exemption to unfair dismissal rights exists for those who are not covered by a modern award and who earn above the high income threshold of $142,000 per annum. To avoid such a claim, you must follow a fair process in relation to dismissal. While unfair dismissal is the primary claim employers are often worried about, a different type of claim which can be made regardless of how long an employee has been employed for is an adverse action or general protections claim. From an employee's hire date, they have entitlements to workplace protections, including access to a benefit such as a leave entitlement, safety in the workplace, and discrimination. If actioned or threatened action is taken by the employer against an employee's workplace right, or action is taken due to a protected characteristic, then that may amount to an adverse action claim. To avoid this type of claim, you will need to prove that there was a valid reason for the dismissal or the action taken against the employee relating to performance or misconduct, and that the reason did not relate in any way to the protected characteristic. For example, an employee has a workplace right to take leave. If an employee takes a sick day every week, notifies the company in the correct way, and provides the relevant medical certificate evidence, the employer is unable to terminate their employment for this reason of taking the leave, as they are exercising a workplace right for their leave entitlement. Process is absolutely key. You are handling the employee a claim on the plate if you do not follow a fair process. In relation to misconduct, a fair process will include inviting the employee to a meeting in writing. In the letter inviting the employee, the alleged conduct or behaviour must be specifically stated in as much detail as possible. Even better is to refer to the particular policy or contractual term which has been breached. Generally, the employee should be given at least 24 hours notice of the meeting and given the opportunity to respond to those allegations and bring a support person if they wish. During the meeting, they're given an opportunity to discuss the allegations, make responses, ask further questions, and notes should be taken of what is said during the meeting. Before making a decision as to the outcome, the employer must consider the employee's responses, any mitigating circumstances, and any evidence to substantiate the allegations. For example, in a recent case, a truck driver was terminated for urinating outside the entrance to a customer's warehouse. Although this was a valid reason for termination, the employee was awarded $16,000 because they terminated the employee without giving them a reason or an opportunity to respond to the allegation or put the CCTV evidence to the employee, who, as it turned out, had diabetes and meant that he suffered from urinary urgency. So now let's look at bullying and harassment, which costs Australian businesses up to $13 billion per year. Bullying has always been protected under the work health and safety legislation, but since 2014, workers have been able to make claims to the Fair Work Commission for an order to stop bullying. This type of claim is reasonably cheap and easy to lodge, and we are seeing a rise in the number of claims made, more generally allegations being made in the workplace. Bullying is when a person or group of people repeatedly and behave unreasonably towards a worker or a group of workers at work, and the behaviour creates a risk to health and safety. This does not include reasonable performance management. Reasonable management actions conducted in a reasonable manner is not considered bullying. We do see a lot of employees who are being performance management claiming that they feel bullied, but be assured reasonable management action, if conducted in a reasonable manner, is not considered bullying. Just be conscious of how and where you give feedback. For example, give constructive criticism in private and be respectful. Harassment is unwelcome conduct that offends, humiliates, and intimidates a person related to a protected characteristic, for example, anti-discrimination based on gender, race, or ethnicity. Examples of bullying and harassment can include aggressive or intimidating conduct, unreasonable work expectations, and exclusion from social events. The problem with bullying and harassment is that it's a matter of perception. So what one person may consider to be insulting, the other might find funny. It's important to deal with grievances and all grievances in a very structured and processed way. That's why it's very important to set it out in your policy of what a grievance is, how it's going to be dealt with by the employer, any investigations that are going to be taken place, meet with each of the employees and address the concerns as soon as possible. At work, the obligations and actions out of work or during breaks. So for example, we had a bullying and harassment case where the Fair Work Commission held that bullying conduct at work encompassed both the performance of work at any time or location and when the worker is engaged in some other activity which is authorised or permitted by their employer. This could mean inappropriate internet use during breaks because you as an employer allow them to access the internet. It is also not necessary for the employee to be physically at work. In this particular case, social media posts made outside of work hours still constituted conduct which was considered to be at work because the worker with whom they were directed read them while they were at work. In this case, the Fair Work Commission confirmed that the relevant behaviour continues for as long as the comments remained on Facebook. It is important that you ensure that you have and enforce all the policies around appropriate conduct in relation to work colleagues and interactions with work colleagues at all times, particularly in relation to social media and internet use. So there we have some food for thought. I'd like to open up the floor now for some questions. If anyone has any questions, please pop them in the question box and we can address those for you. Alternatively, if you do consider that you have a question following on from the session, please feel free to pop myself or Ainsley or Michelle a message and we can address those for you as well. It looks like we haven't got any questions that have come through so far, so what I might do is pass you back to Ainsley to follow on. Thanks, Ainsley.
Thanks, Laura. Hi, my name is Ainsley Coomber, and thank you for joining us today. As Laura mentioned, please feel free to ask any questions along the way in the chat box on the left. I would like to let you know about the new enhancements and features available in this year's release of Aussie Time Sheets version 8.0. I will also be sharing some exciting news about future industry-changing applications we have on the horizon. But first, I would like to inform you on a local payroll system, Paytech. This system has been designed and developed in Australia to work with the Australian PAYG system. Paytech is a small business payroll application and provides everything you need to manage your payroll. In light of the strict employee payslip policies explained earlier by Laura, this great Australian payroll system can ensure you comply with the Fair Work legislation. The key features of the system include an inquiry screen, which allows you to review every item on an employee's payslip. The reports are laid out in a clear and easy to understand report format, and the payment summaries can easily be printed for all employee types. We can set up automations, so emails are automatically, payslips are automatically emailed to employees, and the system also accrues leave based on hours or a percentage of work, or the percentage of hours or amount earned. The system automatically integrates with our Aussie Time Sheets software, so you can import your timesheets from one system to the other, avoiding manual data entry. So launching in January 2008, version 8.0 will see some great improvements to our software for our basic and premier packages. Our new timesheet view, you can easily see a single employee's timesheet with the additional information on a new visual layout. This feature will enable you to view a timesheet report for an individual employee and be able to view their profile image, which department they belong to, which clock they're allocated to, as well as their scheduled rule which applies to the employee. The current daily timesheet view is still available, and this new timesheet view will be available through our Premier version. The next new feature is our payroll period selector, which you can see in 1 second, sorry. Yep, there it is. And you're able to configure your exact pay period, so you don't need to manually select the date range across the application. Also in this same area, you can enable RDO functions, and when enabled, you can control the settings of how this is calculated. This dedicated function is designed to handle RDOs, ADOs, tills, twirls, and flexi time, and will automatically balance hours. This feature is beneficial to avoid unwanted overtime and is also available through our Premier version. The next new feature that I'd like to share with you is locations, and that refers to the location of the time clock and the employee. The software settings allow you to tag a time zone to a clock's location. The software settings allow you to tag a time zone to a clock's location and also an employee, for example, to a Queensland or New South Wales stores, or both. This function also allows you to automatically sync the correct time to the time clock to ensure the correct time is displayed on the clock and the clock never gets out of sync. And this feature is also used to update the time for daylight savings. So we have a great special offer for all participants of the webinar today, and if you'd like to take advantage of these new great features, which are available through our Premier upgrade version of our timesheet software, we have an exclusive 10% offer for all participants of the webinar. And at the end of the session, you can leave your details and our friendly sales team will be in contact with you. So what's on the horizon for Aussie Time Sheets? In 2018, we will release some industry-changing applications. We have a dedicated Android and iPhone app for our Premier clients. This will replace the mobile clocking web browser for the end user and will be free to download. The application will record the time, date, location of where the clocking was made, with also offline clocking built in. So this means the data will still be logged even if they have no network coverage or connection. PaySync. PaySync is our cloud payroll API connector app. All Aussie Timesheet software will be able to push data to a cloud payroll application through PaySync with a simple web interface that customers can easily connect and configure themselves. PaySync will connect via API to every leading payroll application in Australia, with the key players added initially on launch. And Aussie Timesheets Net, that's right. Our enterprise-level self-hosted web application will launch in the 4th quarter of 2018. The additional features you can expect to see are powerful award calculations, intuitive staff rostering, plug-and-play time clock connection, and an employee self-service portal app with enhanced dashboards and reporting. So through these self-service portals, employees will be able to request leave, submit certificates such as medical certificates, and they'll also be able to view their rosters. If you have over 100 employees, you're going to love all of this, and it's all at a great affordable price point you won't believe. So thank you for your time today, and as I mentioned earlier, if you have any questions, feel free to pop them in the chat box or get in contact with us after the webinar. Thank you. I'll now pass over to Jordan just to wrap up.
Okay. Thank you to our presenters for your presentation, and thank you to everyone for attending the webinar. If you have not done so already, please fill out our survey, which is on your screen now. And we thank you in advance for your feedback and wish you a pleasant afternoon.